Good morning, Your Honor. This is cause number DC 1919159, Four Corners Development LLC versus Allsall Construction Inc. and Parways alum.
Okay, let's go ahead and get started. Sorry, Mr. Martinez, if you could make your announcement, and Mr. Gasworth, if you can make your announcement.
Yes, Your Honor. My name is Nathaniel Martinez. I'm here on behalf of Plaintiff Four Corners Development LLC.
All right.
Brad Gasworth. I'm sorry, Brad Gasworth on behalf of Parways alum and Allsall Construction Incorporated.
Okay, so this case we'd had set for trial, I think, a couple of weeks ago, and we had continued it to give Mr. Gasworth a time to take a deposition. And I guess in the interim, there was a motion to file to send this case to arbitration. And so I've read all the briefing, kind of know what I'm going to do, but I'm glad to hear argument on both sides.
Thank you, Your Honor. The issue in this case is that there is no distinction by and between Mr. Coe, the respondent counterclaimant in the arbitration upon which he has confessed subject matter jurisdiction, along with his company, Highland Senior Village Living LLC, and the plaintiff in this case, Four Corners Development. Highland Senior Village Living and Theon Coe are defendants and counterclaimants in a first filed arbitration in October of 2019. Four Corners, and if we just go to Mr. Coe's deposition testimony first, and that is on page 113 of
Mr. Gasworth, I guess, why did you not bring this up when we had the trial setting? You asked for a continuance to take discovery. You never mentioned you were going to be filing a motion to compel arbitration.
Well, it's, Your Honor, after I took the deposition, after I got my handle around this case, and why, because I had assumed initially that the case was going to be continued past arbitration because the parties are the same. Mr. Coe is Four Corners Development. He admits it. And further of importance, the issues brought in that arbitration, which were first filed, are the subject matter of a first filed case. And so this case, as I reviewed it after the fact, doesn't even no longer have subject matter jurisdiction. Now, furthermore, it's the actions of Mr. Coe in which he admits in his deposition, and I'll just go through one portion of it. First of all, he admits that he created this company and its affiliated company. And then he admits this in his deposition, and this is on page 212. And then we kind of go through that whole payout.
I know you're pleading alter ego, or you're arguing alter ego. Did you actually plead alter ego?
Well, it's not pled as as anything other than this case does not have subject matter jurisdiction in the court because the plaintiff in this case, Four Corners, is the alter ego of Theon Coe and Highland Senior Village. So
you do plead for alter ego?
Yes, as it relates to my motion to compel. I specifically plead.
No, I mean in your pleadings.
No, I did not plead that in my pleadings. No.
Okay.
But as it relates to my motion to compel, the issue to be determined is whether or not the plaintiff in this cause of action is the alter ego of a plaintiff in an already issued subject matter jurisdiction arbitration and it's not just a causal connection. It's a direct nexus connection between not only the parties, but the issues in dispute, and the issues in dispute that have already been confessed as the subject matter jurisdiction of a binding arbitration agreement between Theon Coe and Highland Senior Living Village and Allsall. Mr. Coe admits, he even signs, if Your Honor would look on my appendix exhibit numbers 1 and 3, Mr. Coe signs a release on behalf of Four Corners on the first one, Exhibit 1, identifying himself as the CEO of Four Corners. And then in Exhibit 3 of the appendix, signs it again as Theon Coe, and his title on this one is owner. I do not believe that there can be any question of the direct distinction. Furthermore, the testimony of Mr. Coe that he clearly stated that Four Corners had never worked on any other project and has not worked on any other project other than the project that is the subject matter of the binding dispute resolution. And he further admits that he withheld monies. He says in his deposition, quote, "There's some of it pay application proceeds, that he allows me, keep it during the draw process, that I keep it, because sometimes he borrowed money from me and that's part of the payment. So he just, just keep those differences. Question.
I guess my big issue is that I don't see how you avoid a waiver argument here. You clearly invoked the subject matter of this court, and then your client's not a signatory, and the only basis you said to, obviously usually non-signatories can't get in unless it fits within one of those exceptions, and your exception you alleged it hasn't been pled. And so I don't know how you get over those two issues, just to be honest.
Well, my position is this, that the plaintiff has waived its right to litigate because the plaintiff is in fact the alter ego of a previously and first filed subject matter jurisdiction arbitration.
I've never heard of anyone. Is there any case law about waiving your right to litigate?
Well, Your Honor, the case law on waiving your right to trial, my clients also has not invoked the litigation process, has conducted no discovery in this proceeding, has not done anything, has not asked for summary disposition. I do not believe that also has waived its right to compel arbitration. I further believe that the plaintiff is bringing this action in bad faith because it is in fact the alter ego of another company.
How can you say that when you move for a continuance on a trial setting and then you requested depositions to prepare for a different trial set?
Well, during that deposition, Your Honor, and what I discovered was that
that's not the point. It's the question is whether or not you've invoked the court's jurisdiction or waived your rights. I mean, if this isn't a waiver, I don't know what is a waiver. Maybe there is no waiver, but it clearly you had a trial setting. You requested discovery during that. You requested that you needed all these other things. The court gave you the right to take the deposition. You never pled, you're a non-signatory, and you've never pled alter ego. And have you pled any of the exceptions at this point in your pleadings?
In my motion for leave to the First Amendment answer.
No, I'm saying in your pleadings, in your answers,
Your
prior to the trial setting, you never pled any of the exceptions.
No, Your Honor, but if you go back and look at the motion for continuance, you'll see in the motion for continuance that the parties agreed that the arbitration was going to be the means in which this matter. If I had thought, it's a mistake that I made. I mean, there's just no denying it. This issue should have been brought beforehand, but in my opinion, I do not believe I've waived the right to compel arbitration in this action. I believe the case law supports that. I believe that the facts that the plaintiff in this action, by his own admission, is in fact the alter ego of the owner and himself that is in the subject matter jurisdiction of an arbitration where these claims have been brought, prevents this plaintiff from also circumventing that arbitration process by then filing this action.
Mr. Martinez, do you agree with Mr. Gasworth?
I do not, Your Honor. Is it okay if I share my screen, Your Honor?
Sure, absolutely. Let me enable that. Sorry, just give me 1 second. Go ahead.
Okay, let me just see if I can figure this out. This is all new to me. I apologize.
It's okay.
Let's do share screen. I think the first stop in all this, Your Honor, is just to look at the case law, right? And I apologize. I don't know how to present it so I can show it on Zoom, but you can read that right in front of you.
Yeah, I can.
Okay, so we got to think about what their burden of proof is. What they're asking the court to do is effectively have a separate, distinct legal entity, Four Corners Development LLC, be sent to arbitration. And that's what they're asking this court to do on an arbitration agreement that was between two separate entities, Allsol Construction Inc. and Highlands Village Senior Living LLC. Mr. Gasworth keeps talking about Mr. Coy, and I want to just correct that for the record that it's not Coy, it's Coy. Mr. Coy is somehow one and the same of all these entities. But when asked about this specific allegation during Mr. Alam's deposition, who sat as the corporate representative for Allsol, his statement was, well, I thought they were the same because Mr. Coy was representing both. But the fact that he's representing two different companies is insufficient. It also, as you mentioned, Your Honor, doesn't speak to the fact that Alam himself isn't even a signatory to an arbitration agreement. And this is a claim against Mr. Alam individually as well. But I want to talk about what the burden of proof is. We have to decide whether the parties agreed to arbitrate. That's the first stop in determining whether or not arbitration should be compelled here. And you don't resolve doubts when it comes to a non-signatory or indulge a presumption in favor of arbitration if the party is not a signatory to that arbitration or the arbitration agreement. The burden is on.
So let me just ask this, and I don't mean to, cut you off there, but
no, I understand.
So if you could get to the exceptions for non-signatories,
yes,
is that part of your PowerPoint?
Yes, I can. So, the Texas Supreme Court has.
Let me ask a question about this. So, they're claiming that I guess the exception, the one that they brought up that I saw, was alter ego. Is there anything in the case law that talks about whether, because you've had some unusual, I think, arbitration opinions out of different courts of appeals. Is there anything that says that you don't have to plead these in order to assert them as a basis for an exception or to allow you know what I'm asking? Basically, they're trying to bind a non-signatory. There's 6 exceptions essentially that allow you to do that under the federal courts have found that and some Texas courts. Has there ever been any discussion saying one way or the other that you need to plead or you don't need to plead those as defenses?
So just the general rule of pleading an affirmative defense, alter ego, we cited a case in our papers, Your Honor. I don't have that in front of me, but we cited a case in our papers that says in order to pursue an alter ego claim, it's either pled or it's waived. And at this point, it hasn't been pled, and the pleadings deadline has expired at this point, so it hasn't been pled.
I know that's generally the rule. So what I'm trying to get at, I'm very strongly inclined to rule in your favor because I think there's waiver, and I don't think they've pled this, and I think there's a whole variety of issues. But I just want to make sure, for your sake and for mine, that there isn't some case out there that says, hey, you don't need to plead any of these. You've seen there's been some very unusual arbitration cases in the past where there's such a strong presumption generally in favor of arbitration that they'll bend over backwards to say, okay, even if you don't plead something, you can still assert it. Is there any case law like that in non-signatory context in Texas state court?
I have not seen that case law, Your Honor. So no, I can't comment on that. But what I can say, Your Honor, is it's not going to hinge necessarily on that. In this case, the question is, did they present enough evidence to suggest there's even an alter ego relationship? Look at the case law on alter ego, Your Honor. If you look at just distill their arguments in their papers are, Mr. Coy said that Four Corners was developed for this project, or that Mr. Coy.
Let me just ask you though, you're not waiving the argument that they failed to plead it, are you?
Oh, not at all. In fact, we made that argument as a response in our papers, Your Honor. We said, and specifically, they waived alter ego and therefore should not be allowed to pursue alter ego as a method for compelling us to arbitration. They wouldn't even be able to do it, Your Honor, anyway. Even if this court were to hold an evidentiary hearing, there would be no evidence to support an alter ego finding. Alter ego burden is very high in Texas courts. I've litigated a ton of alter ego claims, and it's hard to prove. And in this case, it's especially hard because he took the deposition of the corporate rep of Four Corners, and he heard from the Four Corners rep, from his own words, they're not even the same common owners. They're different owners. Different companies own the owner entity in the arbitration, and individuals own this entity in Four Corners. And so he continues to say and try to blur the fact that the arbitration concerns similar issues and facts. And I want to just point out, he's mischaracterizing what the purpose was for the continuance. Just like any case where there are similar attorneys and parties on the other side, if one case gets decided in favor of another party, it could very well obviate the need for another trial. And I recognize that. In fact, I believe that if we prevail on Tuesday, that might obviate the need for arbitration because their backs are going to be up against the wall with a $500,000 judgment against them. So that may very well result in some settlement discussions later on down the road. And so when we were filing that motion to continue, we were thinking, at least at the time, I was engaged in settlement discussions with Mr. Gasworth's predecessor, Mr. Adcock. I thought, well, let's see what we can do. This court denied that. And we got ready for trial. We did everything we needed to do to get ready for trial. We filed everything on time that we needed to file, and we were ready to go. And then I'll remind the court at last hearing, and I think you're very well aware, Mr. Gasworth never said at that hearing, we need to postpone this pending arbitration. He said, we need to postpone this because my associate went AWOL and I need time to get ready for trial. And he represented to this court that he was going to get ready for trial and all he needed was a deposition.
I remember that very vividly. This will be a story I tell my interns. It's sometimes you try to give an attorney a break and they don't always, sometimes they will use that for other purposes. And I feel that's what's happened here. I'm very, I'm kind of disturbed that.
Well, Your Honor,
brought up
Your Honor,
at the.
I'm just trying to protect the record here from my client, and I do have a case that says it does not have to be pled.
Okay, go ahead.
422 Southwest 3D 68. The only issue on a motion to compel to prove alter ego is it needs to be evidence before the court, not pled. And I would ask Your Honor.
Can you share screen that case?
Excuse me?
Can you share screen that case so I can see it?
Yes.
What was the citation again, Mr. Gasser?
422. Let me find the specific quote. Here it is, claims against non-signatories.
Okay, go ahead and share screen this.
Sorry, where am I? Okay. Here it is, can you see it?
Okay.
Okay, then the issue was where is it? I may have to go back up to the head notes to find the specific. Oh, here it is. Here it is. The record contains no evidence of alter ego. Corporate veil can be pierced on the evidence of alter ego. We've disagreed with GPC that we must presume Creedy's pleadings are true and that evidence of alter ego is not required. The Dallas Court of Appeals and several district courts order non-signatories to submit to arbitration that in the absence of evidence of alter ego. In order for an arbitration to a clause to be non-signatory, the party seeking arbitration must introduce evidence supporting a finding of alter ego.
Well, it doesn't say that you don't need to plead it.
Yeah, I read this case, Your Honor. I know. This is the Glassell case. I was reading this yesterday. This concerned an issue of whether or not the pleadings alone were sufficient to support alter ego at the time. And the distinction was whether the party had actually introduced evidence of alter ego and not just pled it. So this is a different question what your court is asking, which is, but it also goes to what I was saying, which is evidence is necessary to show alter ego. And in this case, there just isn't any evidence of it. There isn't. And I know Mr. Gasworth disagrees because he wants to think that Mr. Coy is committing some sort of nefarious act as it relates to having an interest in multiple companies. The fact that Mr. Coy represents more than one company on this project is not in and of itself a problem. It's not fraud. It's not criminal. There's nothing wrong with what he did. They keep separate bank records. They have separate EINs. They have separate agreements. They have separate roles on this project. And none of the evidence that Mr. Gasworth is alleging and that defendants are alleging here would be sufficient in any courtroom to establish alter ego. So I think the court could just deny it just based on that and be fine because the record will speak for itself. There isn't any evidence to support this claim of alter ego to the extent that Mr. Gasworth wants to hold a non-signatory Four Corners development to binding arbitration. It's just he hasn't met his burden.
Your
And
Honor,
I'll also say this, Your Honor, really quickly. Mr. Gasworth and Mr. Adcock made this allegation in 2019, if that tells you anything. They waited until after the first setting to try to use that allegation as a basis for moving to compel arbitration. In fact, I have an email from Mr. Gasworth where he says, I'm going to move to compel arbitration if he filed this Four Corners lawsuit. And they never did. And I know why they didn't, because they probably looked at the same case law I looked at and could tell that this was not going to hold water in court. And the fact that they sat on their hands for this long on this issue and waited until now to change their position because things didn't go their way at the first trial setting when they tried to ask for it a continuance, that is a change in position, which is facially prejudicial, which is another reason why the court should deny the relief.
Your Honor, I just want to raise this one statement made by Mr. Coe in his deposition, which proves alter ego, because he states here and admits in his deposition that when he received monies from the bank that were pursuant to a pay application that included funds owed to Four Corners, that he did not pay Allsol those funds and instead kept them so that Allsol would not have to write a check to Four Corners. He says it right here in his deposition. That proves common interest, common actions, common ownership, alter ego.
It doesn't, Your Honor. It doesn't prove that. And in fact, this came out in Mr. Alam's deposition, who's the also corporate representative. He said himself that he agreed that that was okay to do. They're scrambling, Your Honor. And we're ready to go on Tuesday, and we're asking the court to deny this motion.
Okay, I will go ahead and deny the motion to compel. Did you already submit an order for me?
I have, Your Honor.
Let me look that up real quick and make sure we have it.
It's pretty short form. If you need more on it, I can do that.
I might want, is it clear that it's denied for failure to plead, waiver, and
no, it's just a straight denial, Your Honor, but we can change it up if we need to.
Let me see it real quick. Proposed order denied. Okay, let me see. So Rhonda, I'm having problems. Let me share screen this. I'm having problems printing here. Can you print out this order? It was filed. What day was this filed? It's right here, Rhonda. If you can see my screen, go ahead and print that out if you don't mind. Proposed order denying motion to compel. All right, so you guys are set for trial next Tuesday. How long do you think this case is going to take to try?
A day.
I think 1 day, Your Honor.
Okay.
Your Honor, just to be clear, you're also denying their request for alternative relief to amend their pleadings, correct?
Correct.
Okay.
And Rhonda, once you print that out, can you come in here? I have a question. Okay. All right. Are we? Okay. Let's go to the next hearing. Thank you, guys. You guys be safe, and we'll see you next Tuesday.
Thank you, Your Honor.
Okay. I think our next hearing is a summary judgment. Is that correct?
Yes, Your Honor.
Short v. Myers.
Yes, Your Honor.
Yes, Your Honor.
Okay. And I've read all the pleadings in this, but I'll let you guys make arguments. I'm pretty sure I know what I'm going to do. All right. Do y'all want a record for this?
Yes, Your Honor.
Yes.
Okay. Tony, let's go on the record on cause number DC 193357. Kanye Short versus David Myers. Counsel, make your appearances.
Lauren Jobin for the plaintiff.
Preston Hino for the defendants.
All right, let's go ahead and proceed.
Yes, Your Honor. We're here on the defendant's partial no evidence motion for summary judgment based on only the gross negligence claims alleged against defendant, the Copier Guy LLC. As the court is well aware, in a gross negligence case, there's both a subjective and objective element in this case. We feel that there's been no evidence shown that rises to the level of gross negligence against the Copier Guy. The Copier Guy is a 3-person company in which they hired in 2015 defendant Myers as a partial driver of a box truck. The box truck in question is below any sort of weight limit where it requires the paperwork and stuff filing, for instance, a tractor trailer. In this case, my client followed the state law of the only thing it required was a valid driver's license. He looked into that. He then sent it to the insurance company. The insurance company then said, "Okay, you're good. He's good to drive." Plaintiff is making a big deal of a DUI that occurred 22 years prior. There's been no allegations in this case of intoxication on behalf of Mr. Myers.
I'm sorry, just give me 1 second.
Sure.
Yes. My Odyssey is working. Can you find out what's going on? I'm able to log on to the system, but I can't log on to Odyssey. Do I have to put? I've never seen the same password. So can you just call All right, sorry, go ahead.
Sure. Fact of the matter is, in this case, it appears that plaintiff is trying to hold the Copier Guy and Mr. Myers to the standard of a interstate trucker by stating there was no background checks, safety manuals, regulations, safety policies that would be required in an 18-wheeler tractor trailer incident. That's not the vehicle at this stake. My client followed all the applicable state laws, Texas state laws, so therefore, from an objective standpoint, we feel there's been no evidence. Further, subjectively, my client knew Mr. Myers for years. They've been friends for quite a long time. He knew he was a safe driver. He sat in the truck and went and explained all the gears and operations and how they worked. To hold a small company like this for gross negligence, a 3-person company, it just doesn't reach the level of gross negligence. And for that reason, we're asking this court to grant the motion.
Jobin?
Your Honor, I think it's pretty clear from the deposition testimony that was attached to our response that there is a genuine issue of material fact with respect to Copier Guy's gross negligence, both in hiring Mr. Myers and also in negligently training and supervising him. While they're not an 18-wheeler, they're still governed by the federal regulations, and they still have requirements when they're hiring somebody to drive a 10,000-pound box truck. They need to call prior employers. He testified that he had driven for food delivery trucks before. He testified that he based his opinion in determining he was qualified simply on playing volleyball with the driver for 20 to 30 years before, and that he had a valid driver's license. He made no inquiry whatsoever into whether he was a safe driver. He did not ride around with him in that vehicle. He simply gave him a 30-minute, here's the way it works, here's how you open the lift gate. So I think all we have to do is produce a mere scintilla of evidence as to our claims as to gross negligence. And gross negligence, both elements can be proved by circumstantial evidence. Now, as to the negligent supervision and training of Mr. Myers, when I took the CEO of the Copier Guy's deposition, he testified they keep no paperwork whatsoever. They have no safety policies whatsoever. They have no policies regarding the safe operation of that vehicle. They don't do any annual reviews. I mean, they literally keep 0 documents whatsoever. Now, I understand that it's a small company and I get that, but that doesn't exempt them and mean that they're not subject to the regulations that they have to make sure that these drivers are qualified before allowing them to operate box trucks, 10,000-pound box trucks on Texas roadways. And a simple inquiry, when I deposed the CEO, I showed him this driving record, and he said, I don't do anything other than confirm insurance company says we've got a valid driver's license, so we're good to go. I think that we have raised a genuine issue of material fact as to our claims for gross negligence as to the copier guy. And I believe that the summary judgment, I mean, it's a no evidence summary judgment. I believe that it should be denied.
Response?
Yes, Your Honor. They bring up these federal regulations. First, this is a local vehicle delivery. It's only used in the DFW area. He's a part-time driver, and mostly the federal regulations require it for vehicles that have a tonnage weight of over 26,000 or 26,000 pounds, and this vehicle is just 10,000. So those federal standards aren't applicable in this situation. Rather, the only thing that's required is the regular driver's license, a Class C. It was checked. Insurance company checked it out. It doesn't meet the objective element.
Is that the only basis for your gross negligence claim, Ms. Jobin?
No, Your Honor. The basis for a gross negligence claim is that going through after the deposition of the CEO, there was absolutely nothing done to determine whether this guy was a safe driver. And I understand whether, because he's operating on Texas roadways, I think that the evidence, I think it's a fact issue that should go to the jury. They should be allowed to hear evidence of the fact that that all he did was play volleyball with him for 20 to 30 years, didn't give him any training whatsoever, didn't supervise him whatsoever, and let him operate that vehicle. And consequently, then this collision occurred and Ms. Short was in. And this seems like a way to kind of hamstring the plaintiff so we can't produce that evidence, which I think is relevant, and it should be something that the jury should be allowed to hear. And I think it was pled pretty clearly and throughout the deposition that we attached to our summary judgment response that simply getting a driver's license confirming is not sufficient. While they're not, I mean, they're still under the purview of regulations on Texas roadways, and they still have to operate as a company and ensure that these drivers are safe. And had he done a simple cursory evaluation of his prior driving record or contacted any of his prior employers, he may have found out that there were issues with whether or not he was qualified to operate this vehicle. And so I think that this is evidence that should be allowed to go in front of the jury, because we've raised a genuine issue of material fact with respect to the gross negligence of their hiring of Mr. Myers, and certainly of their supervision of him and training, considering they have zero training, zero policies whatsoever as to what will be the safe operation of their vehicles. Whether he's part-time or full-time is irrelevant. And so that's our position, Your Honor.
Okay. Well, you know, what I typically do in these types of cases is that I'll usually kind of just hold my opinion on, or hold my decision on this until closer to trial, or sometimes even during trial, just to see if there's enough evidence that gets through at trial to actually submit this to a jury. When are y'all set for trial?
In April, Your Honor.
April, so.
And I was going to also ask you, do you want to, you don't have to, don't feel at all obligated. I really doubt we'll have jury trials then, but I can leave you guys on the docket for them, or I can move you if you guys just want to stay and address this later.
I'm fine with you keeping us on the docket in April.
That's fine with us as well.
Okay.
If
Have y'all been to mediation already?
It was we did, I believe it was before Ms. Jobin was on this case. It was another attorney with her office. It was back in, I want to say December of 2019, I think, or November, around there, maybe October, late 2019.
Do y'all want to, would it be useful to do mediation again, or do you feel like you've kind of
I'm not.
background, or?
I'm not opposed to mediation again. I do feel like the first time we did it, it was a bit early, I think, discovery of this case. I will say we mediated that time with Mike Bassett. And since then, actually, we've kind of gone into more business and operations with Bassett's firm. So it might need better to have a different mediator since we started doing more work with him around November of this year or last year.
Yeah, I mean, I'm fine if, I think we just recently sent another demand. When the case came to me, I took this deposition because the attorney that was handling it is no longer with the firm. So I wasn't privy, I wasn't at the mediation, obviously. So I don't think it would be a bad idea if counsel.
Who would you guys like to use?
I would probably like to use Mike Carnahan.
I like Mike. I use him a lot. I'm concerned if we have an April trial setting, and I know how Mike's been busy. I just am concerned that he might not have any openings until then. So,
well, I can reach out to Nancy Carnahan. I think I just got in with him like last week for next month, so we might be able to.
Yeah. And it was also, there was a different adjuster involved as well on our side. So, the first mediation.
Is there a backup mediator you want to talk about, or do you just want to try to get Carnahan?
I'm fine as well with Mike McCullough or Jim Hitzelberger. I'm not sure.
I don't, no offense to either. I don't want to use either one of those mediators.
Okay.
I don't think
That's
it'll client. So,
Is there someone else you like, Ms. Jobin?
I mean, we could try maybe Bill Ucherick. I know he's over at McCullough Mediations. I've heard that he's been doing a good job.
I don't know anything. I'd have to do some research into him because I don't know anything. I've never used him.
So you guys aren't using like Ken Rubenstein or King Pfeiffer or?
We're okay with King
Mark
Pfeiffer.
Mark Gilbert may.
And we're fine with Mark, but I know Mark actually has even, from what I recall, harder scheduling issues right now than.
That would be my ideal second choice, but he's so hard to get into right now.
What about, or Carl Ginsberg or Jim Jordan or Marty Lowy or?
I would agree to Carl Ginsberg.
I'd have to look into Carl. I've never used him. I can look.
Neither have I.
Why don't we do Carnahan and then Ginsberg as a backup? How does that sound?
That's fine, Your Honor.
Yeah, that's fine with
And
me.
if you guys want to agree to somebody else, I just, as much as I always enjoy seeing you guys, and you guys are, I'm not, this is no form of criticism whatsoever. You guys are both very professional, good lawyers, but it's always, I assume you guys can choose somebody. So, but I would I've had a lot of good luck with Ginsberg. Like he's usually pretty easy to get into, and he's settled quite a few cases for me. So you might want to give him, that's former Judge Ginsberg. So, and you can, I've been able to, literally schedule him the next week on emergency mediation. So if Carnahan's not available, maybe you can give him a shot. So, but anything else we need to chat about, guys?
No, I don't think.
Okay. All right. And did you submit an order for us, Ms. Jobin?
Yes, Your Honor.
Let me make sure I have that.
Let me make sure I'm telling the truth. I should. Or I've said that before, and then it's not been the case. Do you see one on there, Judge, or do you want, I can?
I'm looking right now. Let me see if I can find them. Yes, you did. Rhonda, can you print out the proposed order denying no evidence summary judgment here? We're having some problems with printing. I'm actually at the courthouse today, so I'm having some problems printing. Anyway, all right. Well, go ahead and I'll go ahead and sign that today. And you guys be safe. Good luck with your mediation. I hope it works out. I'd love to hear what y'all think of Judge Ginsberg if he felt he was effective. And I hope you guys have a great day. Okay.
Thank you.
Thank you guys. All right, our next hearing is not for another 15 minutes, so I'm going to go ahead and mute and turn off. You can sign back on in 15 minutes, or you can stay on and just whatever you prefer, but we'll start up at 10:15. Can y'all hear me okay? Is there anyone there?
Yes.
Mr. Zedrick, Mr. Builder, are you guys there? Are they there? I thought I saw them. Mr. Zedrick, Mr. Builder, are you there?
Can you hear me?
I can, yeah, I can now. Okay, so we're here on a motion for continuance, is that correct?
Yeah. Is my video working?
Let me see. Mr. Builders is, Mr. Zedrick's you or not, but that's okay.
I think I can fix it.
All right, Tony, you ready? Tony, you there?
Yes, Judge, I'm ready.
Okay, let's go back on YouTube. Or still on, okay. Let's go on the record on cause number DC 196203, Zedrick versus Builder. Counsel, make your appearances.
Hi, this is Dennis Zedrick, pro se for Dennis Zedrick.
Stanislav Builder, defendant pro se.
Okay, so we're here on a motion for continuance of defendant's summary judgment, is that correct?
Yes, sir.
Yes, Your Honor.
Okay. You guys can proceed. The movement will start.
Yes, Your Honor. I filed a continuance for defendant's eighth motion for summary judgment. I do not have the case file or the emails yet for this case from my counsel, who, as stated in the motion, had to resign for a few reasons, partly due to Mr. Builder filing bar complaints against them and threatening to file additional bar complaints. And then also because there have been, at the time I filed this continuance motion, 65 pro se motions, notices, letters filed by defendant, and 8 various different kinds of amended summary judgment motions for different causes and different things since July. So they're gone, and I don't have the case file. I don't have the transcripts. I think this morning when I'm dealing with these other things the defendant has filed, I think I saw that maybe an email came in from your, what do you call her? Your court reporter, Tony, that there are some transcripts attached today, but I don't know which ones are there or not, and obviously haven't had a chance to go through them. So, and I further don't know how to respond to once I get all the materials from my counsel, which they've said for a couple of weeks they're going to send the case file, and they haven't yet. I don't know how to respond to this SJ, and so it's going to take me some time to figure it out. That's it.
Response? No response?
Sorry, I'm sorry, I was muted. Your Honor, to Mr. Zedrick's comment about the amount of filings, I just calculated there are about 55 filings on record, and if he says I filed 63, that's not even a half. So saying that I'm overwhelming this court is a bit of exaggeration. All file is available online. The argument of the parties is the same as it was in summer, and the motion of summary judgment is on a very simple matter. If I can consent to recording of my minor child, it's a simple yes or no question. The argument is the same. The response has been filed by his attorneys in early fall, if I'm not mistaken, and they were waiting for the leave of the court for me to amend my response original with the affirmative defense, which has been done. And this is why we are hearing this motion now, but not in fall. His attorneys resigned in early January, and then we had a hearing and that it was approved. And then Mr. Zidrik mentions his reason to delay the whole proceeding, that he is not comfortable with ruling, with running the jury trial. But Texas Rules of Civil Procedure explicitly state that this is not a good reason to delay the proceedings. That's not a good cause for give the continuance. And we have a hearing on the last motion and summary judgment on the last cause of action filed by Mr. Zidrik in just 2 weeks.
Mr. Zidrik, do you even want to pursue, are there any counterclaims in this, or is it just, is that the last of the case? Mr. Builder.
A question to me?
Yeah.
This is the last motion for summary judgment. That's the last.
Do you have any counterclaims?
No.
I mean, Mr. Zedrick, do you even want to still pursue this case? Do you want to just, you can dismiss it if you want, and that would end the case. It's called a non-suit.
Your Honor, and Mr. Builder, I'm sorry, I should just say the defendant. The defendant has recently amended during the time that the during that period of resignation, however that works, where the the attorneys file their notice and then they're not working on the case once they file their notice and they're waiting for it to get approved. The defendant filed additional, I hate to try the SJ right now. It seems like the defendant filed amendments to that since what he's talking about, since my attorneys filed their response, he's amended it twice. He's changed his defenses twice. Or adjusted them, or what, I don't know the exact terms to use, but he's changed it. So therefore, whatever the attorneys responded months ago, whenever that was, then that's got to be changed and the case law's got to be researched. But yeah, that's why I filed the motion for continuance on this, because it requires transcripts. I know that much at least. And this idea that I don't really know how to, forgive me, Your Honor, if I'm not following proper decorum here. I don't.
I guess my bottom line is that there's just stuff that keeps happening in this case. It would seem like if both sides are willing to non-suit any claims that they have, we could just end this lawsuit and you guys could be done. Otherwise, we're just going to keep going on and on and on and on and on. And if you want to keep fighting with Mr. Builder, you can, but if you guys would both agree to non-suit this case, it could be over and you guys would stop having to fight with each other. If that's what you want. If you want to keep fighting with each other, that's what I'm here to do, is try to resolve that.
I think that this, however, I haven't been on these hearings for a long time, but was told by Ethan Harima that there's this picture painted that I'm in this active fight. Maybe I even enjoy it. This is 180 degrees from the truth. I mean, there are felony impersonation websites put up in my name, Your Honor. How do you work with felony impersonation websites put up in your name saying that you're a money launderer? This case that was supposed to be sealed, it's on those websites. I don't understand how someone believe discovery was closed whenever that was closed this summer.
Mm-hmm.
I've got to get these websites down, Your Honor. Your Honor, I have to add myself actually as a party, as a defendant, because the websites say that I put the website up about myself. That's why it's a Class C felony.
Okay.
I'm going to have to add Dennis Zedrick as a defendant.
Mr. Zedrick, that isn't a part of your current pleadings, and so I guess you guys need to keep fighting over this stuff. I'm a civil judge, so I can't help you with any criminal matters here. If you need to contact the DA's office, if you think that there's some type of crime taking place, I'm not saying there wouldn't also be a civil cause of action as well, but if you want to keep fighting in this court and adding causes of action, and then you guys can keep fighting over all this, you can. But just you're talking about there being some kind of felony that's being perpetrated, and if that's the case, I'm sorry that's happening. If that's true, it's just not something that this court. I can't. I'm not a criminal court. I'm a civil court. So it was just a suggestion. I thought you guys might want to stop fighting with each other. But if you want to keep fighting and keep this case continuing on, I'm not going to force you to do anything. I'm just making an observation based on the extensive amount of time the court has worked on this case. So I will give you. I
would love to, Your Honor. I have to get these websites down to work, and I don't.
But I'm telling you, there's nothing in your lawsuit about that issue. I mean, that's not something that if that's something you need to do, then either amend your petition here, because it's not in your live petition as far as I know, unless something's been added recently, or contact the DA's office. But that's not part of this case as I understand it. Is it part of this case? Is that something that's in your current pleadings?
Mr. Harima, before he left, Your Honor, said that because discovery and the case was closed, that there'd have to be motions for leave filed to amend that it couldn't be done, and that these other things had to be taken care of first before that could be done. Because it was Mr. Harima's opinion, and I hope you don't get upset with me. This is just what he told me. I wasn't actively involved in it, that the case was being disposed of. So he said, he empathized with me. Yeah, you need to get these websites down, but in order to do it, you've got to amend the pleading. You've got to add yourself as a defendant. Then there's a specific
add yourself as a defendant?
Yeah, I have to add myself actually as a defendant, Dennis Zedrick, because these websites are an impersonation site. And so the case law states that I have to be added as a defendant, because obviously I didn't post the sites about myself, but it's anonymous. So they gave me the case law, even though they weren't going to do it because they were done. And then there's an order I submit to you, and that order allows you to be able to, I can then send the order to WordPress to take these websites down. If you remember when this case started, this started around mylife.com website put up that I was arrested in Addison, Texas. That was one website. Then there's a LinkedIn website put up last March in my name. And now there's a WordPress website put up in my name. And Ethan Harima filed contempt for that this summer. And the show cause order didn't get signed, I guess, because of COVID. Ethan didn't know why, but it didn't get signed for 3 months, from July to September. Ethan said he thinks it was COVID related, but I don't have any idea. So the information has been filed into the case, Your Honor. It just hasn't been put in the pleading because everything was closed. And so in my mind, I could really care less about the defendant when it comes to those websites at the moment. Whether the defendant did it or not, that's separate. The websites exist. It's not a maybe. We can put them on the screen now. I have to get them down.
Okay. I don't know that this is the right, adding them to this particular lawsuit. I don't know if that makes a whole lot of sense, but if you feel like you're going to want to do that, obviously you need to amend your petition and, you know, get those things taken care of. But I do feel like this case has been extensively litigated, and you know, it's your call if you wanted to do that. I'm going to go ahead and grant the motion for continuance. I'm going to reset this to May 14th. Rhonda, go ahead and put this on the docket for May 14th, the summary judgment, and that's what we'll do. So, guys, thank you so much. Good luck with everything, and we will see you on the next one. Okay,
excuse me, there is a TRO by me.
Oh, that's right. What is the TRO about?
Your Honor, we have a jury trial in May, if I'm not mistaken.
Yes.
So is it going to be before or after the jury trial?
It's going to be, I'm going to reset it to the day of the jury trial.
Oh, the motion for summary judgment.
Yes.
Your Honor, if I may respond to Mr. Zidik's argument here, because the dynamic of the case is Mr. Zidik filing a bunch of stuff against me, want $1 million out of me, and a bunch of other stuff. He loses under the TCPA, and the very same day he's amending his pleadings. Then he's losing those pleadings.
Mr. Builder, I'm very familiar with the history of the case. So.
Okay, I got it. So the TRO, it's actually by your suggestion when we had a hearing almost a month ago.
What?
And I was asking to remove the injunctions because if Mr. Zidik is chasing me on the parking lot, he's definitely not scared of me. And you suggested that because of the animosity in this case, you'd rather not remove any injunctions, but you suggested me to file a TRO to mirror the injunctions that Mr.
I don't know that I
has
suggested that, but yeah, that I did. I mean, I remember making a comment along those lines that wasn't what you were trying to do, wasn't the correct procedure.
Right. So, and here's the TRO. So I'm pretty much mirroring the injunctions that Mr. Zidik has against me. Do not count closing the 50 feet. With one exception, do not use email for communicating with me directly. The reason is that since 2017, the communication of Mr. Zidik with me was nothing but a constant torrent of profanities, threats of which, and I quote, "your bottom-eating attorneys" would be the mildest one. I don't want it in my email, and I don't think this kind of discussion is productive.
Well, now, how do you want to communicate with them then?
E-file. E-file system, which allows parties to exchange messages, which has two wonderful advantages over email. First, it has a receipt. You see when the party downloads the document, actually. And second, it ends. When the case is over, the system is down, and the plaintiff cannot message me anymore, which I'd be delighted to.
Mr. Zedrick, response to that?
I don't know, Your Honor, if you've looked at this TRO application that he filed, or if you've looked at my response that took 11 hours to prepare and was filed this morning and accepted this morning.
Go ahead.
I don't know how to respond to this, Your Honor. legally, I don't want to try to sound like I'm playing attorney, but as is in my response, for my layman's opinion, unclean hands, latches, jurisdiction and venue, statute of limitations. He tied no independent cause of action to this TRO filing that he made. If it's ancillary, what is it ancillary to? He has no causes of action left in this case. They were disposed of via SJ. And in addition to them being disposed of via SJ, the statute of limitations ran out on them. They had a 2-year statute of limitations. So if he, this is all fantasy, Your Honor, that in his TRO application, the pictures, I know you don't want to get into this, you don't have a lot of time, and I was shocked to receive this. The pictures that he included to try to fool you on the front page of the filing were from 2018 at Addison PD. The same thing that this lawsuit was filed for, the same thing that he filed 2 causes of action for, and that were dismissed under SJ. Whether it's latches, if Mr. Builder has a TRO here, why didn't he file it in 2018? After he filed the police report against me in Addison that they dismissed without a plea bargain, without deferred adjudication, and the judge's clerk called my attorney to apologize. And the attorney said it was the first time in the history that he's ever had a judge's clerk calling to apologize. That jumped this whole case off because there was a mylife.com website put up that said I was arrested. That website still exists today, Your Honor. Now there's 3.
Okay, so let's talk about this TRO though. What is the unfortunately
there has to be pending irreparable harm coming to him on February 6th. Party seeking equity must do equity. There's jurisdictional problems with it. He has to specifically plead a cause of action. Even if it was true that I was chasing him around in the parking lot last month, or the month before that, or the month before that. There was a child exchange on January 6th. Why didn't he file it before then if he was facing irreparable harm? The defendant, Your Honor, as included in this TRO, which is disingenuous, he filed the same TRO in Collin County in October 2019. And one thing, Your Honor, I know most people on here either lawyer with you or don't, lie. Your Honor, if you ask me a straight question, I'll tell you a straight answer. I grew up on a farm and I'm Catholic, and even if it hurts me, I'll give you a straight answer.
why are you opposed to this? I guess what is the real basis? Like
Why am I opposed to his TRO?
Hear me out. So you don't want him to get within 100 feet of you, as I understand it, and he doesn't want. Why wouldn't he want this? Why are you opposed to him wanting the same thing?
Well, Your Honor, in Collin County, he has 17 permanent injunctions. This isn't 2 guys in a peeing contest. He has 17 permanent injunctions. I have 0. My wife has 0.
You just don't want to have a.
He's going to take this to Collin County, Your Honor, and say, see, Dallas County granted a TRO against Mr. Zedrick. See, he's dangerous too. The idea that there's no harm in to keep the parties separated, we are separated. Having produced proof that I'm chasing him around, he videos everything. Having produced proof that I'm chasing him around the parking lot last month, the month before, this summer, 2020, 2021, having produced the proof. He doesn't have it because it didn't happen.
In fact, I do.
For 2020 and 21?
In December of 2020, Mr. Zedrick and his wife have filed with the court in Collin County a complaint that I was with my daughter on my time at a soccer game where I took my daughter to. And like some months after the event allegedly happened, Mr. Zurich and his wife are complaining that they came to the game, came like 15 steps away from me, and I didn't run away. So technically, I was violating the injunctions and I have to be punished. And this is what this whole case about. And Your Honor, I'm very thankful for the defendant's wonderful legal spiel. Do you trust that a person with such a wonderful legal knowledge that he just demonstrated cannot figure out a simple motion for summary judgment? Out of 6 cases pending against me in different counties, 4 were run by Mr. Zidrick last year. 4. 3 of them pro se. Seriously? Mr. Zidrick keeps amending his pleadings, and he just wants this case to go over and over for a very simple reason. He has lost his case under the TCPA, and the attorney's fees were granted, and Mr. Zig was sending me messages that this case is going to be over, but you have to cancel you have to just drop your claims for the attorney's fees, or I'm going to continue and litigate it to infinity. That's literally what he said, and I have all the proof of that. I have videos from the cameras of the police department where Mr. Zidrick is actually, yes, he does chase me. I'm
What dates?
sorry.
The dates are important.
I'm glad Mr. Zidrick does not argue this fact. And it doesn't matter if it happened a year ago or a day ago.
2018 in Addison.
2019 in Frisco.
3 years ago.
2019 in Frisco. Your Honor, I'm sorry, Mr. Zidrick wants to continue this case to infinity, and I want this case to be over. That's why I'm filing a motion for summary judgment. And it just, Mr. Zidrick cannot amend his pleadings because that scheduling order does not allow it. Mr. Zidrick cannot file any more discovery. They tried to file for an extension in summer, and you denied it already for the same reasons. If he wants to file another lawsuit, he could.
So I'm looking, you said you filed something this morning. I don't see it if you did.
Are you talking to me, Your Honor?
Yeah,
Dennis?
Mr. Zedrick, you said you filed something. I'm looking at it. I don't see it.
Yeah, it's called Plaintiff's Response to Defendant's Second Attempted Ex Parte TRO and Plaintiff's Motion for Sanctions, set on February 5th. I called Rose because this thing is so last minute emergency. I called Rose this morning, and she said she was accepting it right then when she had me on the phone so that you could look at all the exhibits that have been.
Oh, I see it. Okay. It was a different place. Okay, let me look at it.
Your Honor,
Give me a second.
general,
Give me a second.
I'm sorry.
Mr. Builder, do you have any active causes of action at this point?
I don't believe I do. And as I mentioned, I wanted this case to be over. I mean, I could have added one.
All right, I'm gonna, he's right. There is no active causes of action. There's not going to be a basis for a TRO then. So I'm going to go ahead and deny the TRO. Did you submit an order on that, Mr. Zedrick?
Yes, sir. They didn't, along with my 11 hours preparation on this retaliatory TRO application. Yes, Your Honor, I did. I don't think Rose accepted that yet. Your Honor, I filed that order maybe 15 minutes before this hearing started, along with the motion for continuance order. And I left
go ahead and email those both to Rhonda, and we'll go from there. All right, guys.
Your Honor, excuse me. For the record, Mr. Zedrick wants sanctions against me for the TRO. I don't think this is
I'm denying the sanctions. Guys, I think I don't know how you guys can work anything out on this case, but anyway, I would try if you can, but if you can't, you can't. That's fine. All right, we'll see you guys back here in May.
Your Honor.
Thank you.
Your Honor.
Yes.
Are you there?
Yes.
I would say that I did file a motion to compel mediation. You have it. It's not set yet, but I'm the one who filed that, Your Honor.
Let's go to mediation.
I agree. Mr. Builder doesn't want to. He wants blood. The truth comes out. I filed it.
Your Honor, it's a simple motion for summary judgment, and we have nothing to mediate here. It's not a commercial dispute. It's a question if I can or cannot consent to recording of my minor child. There is no ground to mediate here, and we already got the mediation. We had the mediation on this case, and it failed. There is, it's going to be a waste of time. Seriously, Mr. Zedrick just wants his attorney's fees to, from the TCPA to go away.
That's something to mediate.
But I'm not doing it.
You're going to do it if I order it.
I mean, I'm not giving up the attorney's fees. Yes, mediation, of course.
That and the order was submitted, Your Honor, a few days ago. It was accepted, but I hadn't set it for hearing because I had to deal with this TRO application that came in.
Have you guys been to mediation before?
Yes.
Your Honor, if I may, it's in the mediation application.
Who did you go to mediation with before? Do you remember?
Gary Berman in December 2019. So some time has passed. And I would ask you if you like to reach out to Berman, if you're allowed to do that, or to any of the counsel involved. And as it's stated in the mediation application, I believe it would have settled then, Your Honor. And then the reason it didn't settle is because defendant's former counsel, I would less blame defendant for this. I don't really know the inner workings, but the long and the short of it is before that he went to mediation, he pressured Mr. Cook and the mediator into requiring that we had to attempt to mediate final rulings in Collin County family case and probation that was issued against defendant in Collin County, injunctions that were issued against defendant, permanent injunctions issued against defendant in Collin County. And they tried to force us to mediate those items if he was going to settle this Dallas case. So where this all gets twisted, I'm not a party to those cases, no matter what he wants to say. I'm not a legal party to them. So to wrap it up, it's all in the motion that I sent whenever you want a chance to read it. But I specifically ask in the motion, if you grant a mediation order this time, to limit it only to this cause number and only to these two parties, so that we can't get in that room and he starts
I'm going to try to contact a mediator that I know. He's a former judge. Let me see if I can get him on the phone. I want to see. want to talk to him about this case.
Your Honor, if I may, a comment on the mediation.
I'm losing connection. I can't hear anything.
You're not, no one's saying anything. We're just in pause right now.
Oh, okay, ma'am.
Let me, okay. Judge Ginsburg, are you on the phone?
Yes, sir. This is Judge Ginsburg, Carl Ginsburg.
Okay, and Mr. Zedrick and Mr. Builder, can you both hear Judge Ginsburg?
Yes.
Yes.
So Judge Ginsburg is basically a 12-year civil judge who recently left office, and he is mediating now. Mr. Builder, Mr. Zedrick have had a number of lawsuits against each other, including one in my court. One of the issues that if I send this case to you, Judge Ginsburg, that is extremely important to note is that I'm only asking you to resolve this lawsuit. I'm not asking you to resolve all the other lawsuits. Do you feel comfortable with mediating, understanding that that's your charge?
Yes, but can I ask a clarification?
Sure.
When you said what happens if they are able, I've done this before, where they are able to resolve all the other lawsuits. Is that something you don't?
No, I don't care about that. I don't want you to make it a the last mediator apparently said that he wouldn't, as I understand it, I guess, and I wasn't at the mediation, this is what's being told to me, that he would only settle this, he would only mediate the case, I guess, if they resolve some issue in the family court that's also dealing with this. I don't know if that's true or what. Anyway.
No, I wouldn't put, Judge, I wouldn't put any preconditions. As a mediator, I believe the parties, if they have a solution that can work big, small, that's up to them. It's a party-driven process.
So just so it's clear that if you can settle all of the cases, that you'd be a miracle worker, but all I'm asking you to do, and I don't want to make a precondition that you have to settle all of these. The only charge I would be giving you would be to try to settle this particular case, because I don't think that it would be realistically possible to try to settle all of the cases in one mediation session. But just if you're comfortable with that, then I would love to have you as the mediator, because I think you're very good. But if you aren't comfortable with that, then I fully understand, and we can send you the next one.
Judge, I'm comfortable with that. Like I said, it's what the parties want to do. If they just want to limit it to this, then
well, the judge wants you to limit.
No, okay, yeah, no, I hear what you're saying, Your Honor. I hear what you're saying.
I don't want this to get. I've had, because of that limitation, if the case had settled, I could have avoided 30 hearings. So I don't know why that precondition was made, or if it was made, but I'm concerned about this case and this case getting resolved. Mr. Zedrick is raising his hand.
Your Honor, the parties are not involved in multiple lawsuits. This is a fantasy. Your Honor, it can be searched. I am not in a lawsuit with the defendant. My wife is a party with defendant, and there is no active suits. There's not this ongoing active suit. The only thing that is active now is probation revocation for defendant.
Okay, guys.
I'm not involved. I can't settle it. I'm not a party for it.
Judge Ginsburg, I apologize if I misspoke. That was what I understood. So all I'm saying is that I just want you to be focused on this case, trying to resolve this lawsuit and not the probation revocations, not the family law disputes, not all this other stuff, just this lawsuit. So there's somebody here. I'm not sure why. Can you go check? All right. Sorry, Judge Ginsburg. Let me give you the cause number on this case. I believe it's DC 196203. And what is your fee for a half-day mediation?
$750 for use your regular civil litigation.
Is that going to work for you guys?
Well, split in half.
$750 aside?
It's per side, yeah.
Per side, yeah.
That's way too much. I'm sorry.
It's cheap. I mean, in Dallas, people charge $1,500, big hitters. So yeah, it's fine.
All right. So, well, one side doesn't want to do that, but one other issue just to be aware of is I did award attorney's fees based on a TCPA motion, and that's one of the things you'll have to mediate is that it's a fairly substantial award. So that's just another thing to work on. Mr. Builder, are you saying you won't pay the mediation fee, or
No,
you don't want to pay it?
If I have to, it's a lot of money for me at this point of my life. I just wanted to comment that Mr. Zidrick, as usually does what he accuses others of doing. His motion for mediation has issues which are not related to this lawsuit, those websites and whatnot. I just want to emphasize that the way this mediation starts by Mr. Zidrick already shows how it ends, because Mr. Zidrick wants it to be limited to this case only and already brings things that Your Honor has properly mentioned, like websites and so on, which are not a part of this case. And Mr. Zidrick would try to mediate those.
Judge Ginsburg is a very experienced judge. He's dealt with a lot of different cases. He's very, very bright, and he's going to be able to figure all that out. He will. He was always the smartest judge, I think, here when I served with him. So I think he can. Judge Ginsburg, do you feel comfortable trying to sort that stuff out?
I do, and thank you for those kind words, Judge.
Is it going to be just half a day?
Half a day.
Zoom? Because I live in Travis. I live in Austin. Traveling is going to be.
I think, yeah, you do Zoom, right?
Yeah, Zoom is fun. Given the pandemic, that's what we've been mostly doing.
Okay, so both parties are pro se. You're going to be required to pay prior to. There's not a huge. This isn't like when you have to do this week or anything, but is there? When do you guys want to try to set this for mediation?
My motion said 30 to 45 days in the order, Your Honor. It said circulate dates in 7 days and hear it in 30 to 45 days. So if you're good with that in the order, it's ready for you to sign.
All right, so the parties will reach out to you, and Judge Ginsburg, I understand completely if you need to get payment in advance on this, and see, you may want to have them send you the checks in advance, and if there's any issues, just let me know. We'll just put in the order that the mediation has to occur within the next 60 days.
Thank you, Your Honor. Shall I give them my email,
yes,
email address?
Please do.
It's Carl, C-A-R-L, at Ginsburg, G-I-N-S-B-E-R-G, and then ADR Group. So like Alpha Delta Roger, ADRgroup.com.
Roger.
All right, did you guys both get that?
Yep.
Rhonda, prepare me an order. Guys, your hearing is over. Thank you so much.
Take care. Thank you.
Thank you.
Thank you, Judge Ginsburg.
Thank you, Judge. And I told you that case the other day. There was a little snafu, but it looks like they got it resolved with the final up paperwork, and hopefully they contacted you today, because I think today's the day to get it done.
Perfect. I don't know one way or the other, but hopefully they did. So thank you, Judge Ginsburg.
Okay, no problem. All right, well, I'll hang up. Is that it?
That's it. Thank you so much.
Okay, thank you. Bye-bye.
Yeah, that's one of my former interns, right? Okay. Yeah, about to start another hearing, but yeah, tell them to come on in. All right, guys. Do we have anyone here on Metrics versus, or Epic Metrics Inc. versus Reddick?
Yes, Your Honor, that would be me.
All right. Real quick, go through your motion.
Okay, yeah, just really quickly, Your Honor. Representing the plaintiff, we have been trying to serve the defendant since August of 2020.
Oh, this is the publication. So yeah, let me just tell you what the issue is.
Okay.
In order to get a order for publication, you have to have a lot more detail than you did in your motion. You basically say you've searched some sites and the person's not local. I really don't like doing publication. I think it should be absolutely the last resort. So you need to have a lot more detail in order to get a service by publication. And so that's why I wanted to have the hearing. I'm sorry it took it so long to get to you.
It's okay.
But
yeah, I think we didn't put enough detail in our actual motion and order, but we had hired a private process server out in California. They couldn't locate him. The last known address was his mom's, and she doesn't have contact with him. She just said somewhere in the LA area. We did hire someone else to do a skip trace on him, and there was absolutely nothing on him. So that is why we are bringing this to you.
Yeah, you need to submit that in your motion, your amended motion, include exactly what's been done. I mean, it just, yeah, it needs a lot more details. So just give me a new affidavit with a new motion.
All right, sounds good. Thank you, Your Honor.
All right, thank you. You have a good weekend. You be safe, okay?
You too. Bye-bye.
Thank you. All right. I haven't seen you guys in a while. Hey, Judge. Oh, sorry, I was talking to them. All right, so what do we hear about today? A motion to compel. Is this a continuation of the previous motion to compel, or is this a new motion to compel?
It's a continuation, Your Honor, of the previous motion to compel in the 5-Star Global versus Null matter.
Okay. What's the status right now?
Well, luckily, Your Honor, we're happy to report that we've been working hard with Mr. Reimer over the past really a few months to reach a resolution of issues that first arose back in July of 2020. But unfortunately, there are just a handful of requests that do require your attention today that we weren't able to reach an agreement on.
Okay, let's go on the record for this. Tony, you ready?
Yes, Judge.
All right. Ms. Krajinski, if you could go ahead and announce the name of this case and the cause number.
Your Honor, this is Jessica Lopez. It's my motion. I'm happy to do that if the court would like me to.
Oh, okay. Now I was going to give her a chance, but if she doesn't want to, she doesn't have to. Ms. Lopez, you can
Sorry,
go.
I was just pulling it up. We're actually not a party to the Null case, so I had the Holton case up.
All right, Ms. Lopez, you can announce it then.
All right, thank you, Your Honor. The cause number is DC 20-08643, 5-Star Global LLC versus Mid-Marketplace PBC LLC. Jessica Lopez and Tyler Bexley on behalf of plaintiff 5-Star Global.
Ben Reamer here for Michael Null and Mid-Market. Good morning, Your Honor.
Morning.
Good morning, Your Honor. Julie Pettit on behalf of the home parties, though as far as I know, I don't think we're a party to anything happening today.
Good morning, Your Honor. This is Sarah Krajewski on behalf of Southfield, and we also do not believe we're a party to anything happening today.
Okay. So, and you guys have conferred on all of this already?
Yes, Your Honor, we have for quite a while now.
We've been conferring on this extensively for months, Your Honor.
Okay. Let's go ahead and how many issues do you said? You just said a couple?
I think we have 6 requests for admissions and then 2 interrogatories, Your Honor.
Are you ready to share screen those so I can just rule on them?
Yes, Your Honor, I am.
Okay, let's go ahead and share screen them.
All right, can you see that, Your Honor?
I can. Let me just see the requests.
Okay. I did it piecemeal in terms of the various requests. The first being request admission number 5, and the responses that you see here, Your Honor, are the amended responses that Mr. Reimer served on us last Friday, January 29th.
It's Reamer. I know
Sorry.
I usually don't pipe up because other folks are going at it, but it's Reamer.
Sorry about that, Mr. Reamer.
No problem.
And Your Honor, if I might just provide a bit of color concerning this particular case. I know we've been before.
I've had plenty of color on this case. The only question I have is the term "as calculated." What does that mean?
Yes, so this case is much different than the Hall matter, Your Honor. It involves a completely separate asset purchase agreement between my client and Mr. Reimer's clients that actually closed in January 2019, so months after the asset purchase agreement we've been talking about on the Hall matter. And in this case, 5-Star Global is actually the plaintiff, and Mr. Reimer's clients are the defendant. So the capitalized terms you see here in this request for admission are capitalized terms that are defined in the asset purchase agreement at issue in this case. And specifically, there were purchase price adjustments to be made in the asset purchase agreement post-closing, including one set forth in section 1.11 of the asset purchase agreement, which dealt with, as you can see here, the net working capital of the seller, in this case, mid-market, and Mr. Nall, Mr. Reimer's clients.
Let me ask you this: the term "as calculated" under the APA, is that defined? What that means in the APA?
What the as calculated is not defined. What happened is that after the asset purchase agreement closed, 5-Star Global prepared and delivered to Mr. Nall a closing balance sheet and schedule, which contained the calculated working capital and target working capital calculations that you see for the defined term.
I didn't get that last part. You keep cutting out.
Oh, I'm sorry. The as calculated term is not defined in the asset purchase agreement. That came by way of a closing balance sheet and schedule that 5-Star Global prepared and provided to Mr. Nall after the asset agreement had closed.
Hey, you're still cutting out. Briefly, Mr. Reimer.
Yeah, Your Honor, this is not at all appropriate for a request for admission. This is one of these very sort of in the middle of this whole case, disputed issues about how this whole sort of post-closing, all these issues went down. There were all these post-closing issues that had to be dealt with. As a technical matter, as Your Honor just noted, as calculated is not defined. As a factual matter, the calculation was performed. It was done by their CFO, who first determined that the deficiency was $12,000, and then determined that it was going to be offset by other amounts, and so there was not any deficiency at all. So then, fast forward, the CFO leaves the company. I don't know if he was fired or not, and the parties to this case, Mr. Baggett and Mr. Lai, come along, and they need cash, and so they say, well, we're going to recalculate it. On second thought, Mr. Nall, actually, you owe us $50,000. I mean, this is an issue for trial. This is a disputed issue in this case. My client can't admit or deny.
All right, I'm going to go ahead and overrule the objection. What's the next one?
Thank you, Your Honor. The next one is request for admission number 14. This is similar to what we were just describing, and it asks that Mr. Nall's or Mr. Reimer's clients admit that simply he has not paid for the calculated losses related to excluded liabilities. Again, terms that are defined in the asset purchase agreement.
It seems like there's a missing word here.
It is. It's a typographical error. It's supposed to read, admit that to date defendants have failed to pay amounts for the losses relating to excluded liabilities. And Your Honor, just in our meeting confers, it was our understanding that Mr. Reimer agreed to amend these responses, and then we were surprised to see that the only amendment that we received last week were in response to the objections, that he amended the objections and not the substantive response. So that's unfortunately why we're here.
All right, I don't think this is, I think this is too vague. Yeah, I agree this is too vague. I'm going to go ahead and sustain this one. Let's go to the next one.
Similarly, Your Honor, request for admission 15 asks to admit that the defendants have not paid the liabilities related to the regional chambers. Again, issues with the purchase agreement that we're trying to narrow for purposes of trial.
Your Honor, if I may, the problem here is that this question assumes that there are any liabilities. That's the ultimate question in the case.
I'll sustain the objection on this one. Next one.
Request number 38, Your Honor. We're not sure why we had to bring this to your attention, but
I'm gonna overrule the objection on this one.
okay, thank you, Your Honor. Lastly, 41 and 42 are similar. So there's employment agreement issues in this case that are actually at issue by virtue of Mr. Reamer's counterclaim, and this just asks.
41 is overruled. (42) is sustained. Okay, what else do we have?
2 interrogatories, Your Honor. Interrogatory number 10. This asks that Mr. Reamer's clients identify all of the facts supporting the fraud claim. His clients allege that our clients engaged in manipulation of financial statements. We really only have 2 issues with this interrogatory, Your Honor, and the next one, which interplays with this response. The first is that we've asked, as we're entitled to know which defendants are alleged to have manipulated the financials. And instead of calling out the specific defendants, they have lumped all of the counter defendants together, indicating that all of them have misrepresented the value of SSC. And then the other issue is that the answer says that the value was misrepresented on multiple occasions.
Does interrogatory number 10 require them to identify which defendant? Let's see, it says providing an answer which made such manipulation. Okay, yeah, that's going to be required. So, yeah, to the extent that you need to, you do need to identify which defendant you believe made such manipulation, if you can.
Yeah, I think I did that in my response.
With respect to Mr. Lai, you indicated that he provided the summary of the 5-star financials, but unfortunately the rest is just lumped in together. He says that defendants contend that counter defendants misrepresented the value of FSG on multiple occasions. So we're just asking for more specificity. Also, Your Honor,
you're going to be he's going to be required to provide more specificity on that if possible. What's the next one?
And, just one last thing on this, Your Honor, if I might. The other issue is that he provided 2 examples of the alleged manipulation, but he indicated that there's been multiple occasions of the alleged manipulation, including but not limited to those examples. So
you're going to need to provide all examples, not just 2, if there are more.
I'll provide as much as I can at this time, Your Honor, certainly.
Thank you. What's the next one?
Lastly, Your Honor, it's number 11. This is the same request, but with respect to the additional statements and omissions that form part of the fraud claim. The response just refers us back to interrogatory number 10 for the same reasons we believe is sufficient.
And I'm the same as number 10. I'm happy to provide all the specificity that we have at this time.
Sounds good.
Great.
All right, guys.
And this, Your Honor, I'm sorry, one last thing. I don't think we have any issue here on the request for production. I think we've resolved all of those disputes, but I just wanted to confirm on the record that defendants will be producing documents and are not withholding documents in response to the request numbers that you see on the screen here.
I've told Ms. Lopez for nearly a year now that we are not withholding anything in this case, so.
Okay, so Ms. Lopez, if you could go ahead and get me an order on this, share it with Mr. Reamer before you send it to me, and we'll try to get that signed. I doubt if you can get it to me today before 3 o'clock, you can email it to Rhonda and e-file it. If not, then it probably won't get signed until next week.
Your Honor, we submitted a proposed order this morning and emailed that to Ms. Pisner.
Yeah, you'll need to do one that complies with my rulings.
Okay, very good.
All right, thank you.